The following is an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome to Island Justice with Roger Batchelor. Today we have the Honorable Judge Brooks, who's going to be speaking about the integrated court in Victoria. Welcome, Judge Brooks.
Thank you for having me.
So I guess the first question that I'm sure any viewer would have is, what is integrated court and how is it different from any other criminal court?
Well, integrated court is a very different kind of experiment, and what we're trying to do is to bring together the resources of the community and try and support those resources in the community to help some of those offenders who have been involved in the justice system and have been involved in it for a long time and keep on coming through it. Our community has experienced the difficulties associated with drug addiction, with mental disorder, with homelessness, and have tried for a long time to try and wrestle this issue into some sort of resolution or to make the situation in some way better. And integrated court is a small part of that much bigger picture.
Okay, so I know that you sit on Tuesdays, and is it always you who sits as the judge for integrated court?
One of the things we've tried to do in integrated court is to have the same personnel involved at all times. And it's the feeling that if you have the same personnel at all times, you will get a familiarity with the issues, the problems, and the difficulties in a large sense, but also with regard to the particular offenders. So there's a dedicated Crown Counsel. I am there for roughly a year's time, and of course we have the same supporting individuals of the ACT team and others who support the people who come through the courts.
So whose idea was it to start this project?
There's a bit of a long history. I'll try and give you a summary of it. It's essentially there was originally a task force, the Justice Task Force, in 2005 that wanted to deal with the issues surrounding homelessness and the problems felt by the community in terms of offending and repeat offending. That was followed up by a mayor's task force in 2007, also concerned with homelessness and the related issues. As a result of that, there were the creation of ACT teams, assertive community teams who dealt with these individuals and tried to assist them. As the ACT teams started to become involved, it became clear that the court could and should find some way to support that work and to assist the ACT teams in making sure that the goals that they had for these individuals, including lives staying out of court, would be ones that we could assist them and support them in achieving those goals.
Okay. So what kind of individual would the integrated court typically serve then?
Typically, and probably there's no typical about it, but typically the individuals that you have are individuals who have drug addiction issues. They may have alcohol addiction issues. They may have mental health issues. They may well have homelessness issues. And those are the kinds of individuals that we deal with. They are also likely to be individuals who use community resources at a very high level. That is, they are in and out of the healthcare system. They are in and out of the community systems. And they are in and out of the court system. And so those individuals are the ones that the ACT team are working with, and some proportion of them come to the court system, and then we deal with them there as well.
I suppose one of the questions that many of the viewers would have is, well, if this court's very specialized, it has these supports, is it easier on people? I mean, if someone's coming with these problems, is the court going to look at their problem, because of their problems, is it going to look at them differently and essentially deal with them in an easier way than they would be in the regular criminal court?
I don't think that you can say that they're dealt with in an easier way. They are dealt with, without doubt, in a different way, but you cannot say that it is in an easier way. It may well be that some go to jail less often, but you have to remember that these are offenders who are individuals who have been to jail, and jail has not worked. And so that jail is not the deterrent that it might be for other individuals. So it is very much a situation in which we try to assist the ACT teams with conditions that will put people on the road to recovery, on the road to not reoffending. And that's a hard road. That often involves a lot of conditions associated with exactly their behavior, so that there are conditions related to curfew, to reporting, even exceptional conditions related to drug screening and those kinds of things that make it very, very demanding of individuals to ensure that they continue on the road of recovery.
So why would those individuals want to be part of the integrated court process then?
Well, the individuals have to agree to come into the system. And they have to agree because information gets shared amongst various community agencies that might otherwise not be shared. So their consent is important. And the reason why they would consent is very much because they appreciate the situation that they're in. They appreciate the continuous dealings with courts, police, coming in and out of jail, having a lifestyle that they most certainly are not happy with. So they, even though they are in the grips of addiction, are still very much of the view that they want to change. And it's that desire to change that founds their dealing with the ACT teams and then leads to their dealing with the court system as well.
Okay. So if an individual is interested in getting into this, would the referral normally come by the individual themselves, or would it come from elsewhere?
Well, the ACT teams deal with the applications, and they deal with them because it is their involvement that is essential. But as to actual referrals, referrals can come from anyone really who thinks that they might meet the criteria of the court. And so, for example, individuals have come before me and I've asked counsel if this is not a person that should go into the integrated court system. And defense lawyers have referred their clients into the integrated court system to see if they would fit there. So the referrals can come from a wide variety of participants.
Okay. And so once the referral comes in, what happens next?
Well, the key part of it is the ACT team assessment as to whether they are individuals who are going to benefit from their involvement. The cooperation is a key element of it as I see it. The ACT team, I'm sure, has their own views of how they should consider somebody getting into the system, but the cooperation certainly has to be a key part of it. As well, the involvement with the resources of the community is a key part. It's pretty clear that individuals of the sort that I've mentioned are individuals who use our services to a much higher extent than the average individual. And indeed, I don't think it's going out on a limb to say millions of dollars are expended on these individuals who use the resource systems extensively. And so the ACT team looks at that as well as a factor in terms of determining somebody who should get into integrated court.
Okay. So once they get referred in, what happens next? What's the typical way of them appearing in court?
Well, obviously they will have a criminal charge that will be part and parcel of them being in court, and so that will be scheduled for a Tuesday morning. And on the Tuesday morning they will come to court, and assuming the preliminary procedural things have been done, such as defense counsel receiving the Crown allegations and what it's suggested the person did, they will then be engaged in our court system if they are interested in the disposition of the case. If they want to have a trial, they go into the trial court system. But if they're interested in disposition, they can come into our courts. In those circumstances, what will happen, just in a very quick overview, is they will come to the court at 9 o'clock. A judicial justice of the peace will find out what's going to be happening on that day with regard to their case. If they wish to proceed on that day, They will then go to what's called a consultation room. In the consultation room are various individuals from the community who are interested in developing a plan that will work for that individual. So there's defense counsel, there's Crown Counsel, the Victoria City Police, who have done excellent work in supporting the integrated court, will be there. The ACT team members will be there. And then they will discuss exactly what is the plan to encourage this person to not reoffend and to essentially get their life in order in terms of a home to stay in, a home first being a critical component of it, and the other aspects of their activities that will break the cycle of offending.
Okay. So you talk about the ACT team members. Who would those be?
Well, they come from a variety of disciplines, and there are several ACT teams. There is one that is associated with the Seven Oaks psychiatric facility. There are those around the downtown area, and they are variously composed of individuals, social workers, psychiatric nurses. That kind of makeup is part and parcel of the ACT team. Individuals who are experienced and used to working with people with significant challenges.
So once they go into the consultation room, they would come back out, I guess, into regular court?
Yes, they would come out into regular court. If all has gone well, there will be a plan devised in which counselor agreed that it's appropriate. And if there are any leftover issues, they will come and discuss them in open court and make submissions as to what is the appropriate way to deal with an individual, what is the appropriate plan that will foster their success and, as I say, try and break this cycle of offending.
So you say plan instead of sentencing.
Yes, it is a plan, but it takes the form of a sentence. So it can have a variety of particular details to it. It can be what's called a conditional sentence order, which is a jail sentence in the community. It can be a probation order, which may have different conditions as well. And essentially, it will involve conditions related to residents, keeping a residence, keeping in contact with the ACT team members, going to whatever counseling or programs are essential for their particular needs, and doing all those activities that are essential, as I say, to the plan that's been put in place to break their offending cycle.
But they would have to enter a guilty plea in order to have that advantage.
Yes, they would have to. Obviously, we deal from people from the very beginning, so we may well have dealt with people who received bail conditions as well. And the bail conditions will be an opportunity for the court and the ACT teams to see how somebody performs. And eventually, it will get to the stage of a guilty plea. As I say, it is a disposition court. And as a disposition court, it will require guilty pleas to some of the charges which are before the court.
Okay. Well, thank you for joining us. We'll be right back in a few minutes. We've got Judge Brooks here with Island Justice with Roger Batchelor speaking about the integrated court.
You're watching an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.
Welcome back to Island Justice with Roger Batchelor, and today we have in the studio the Honorable Judge Brooks, who is focusing on his sitting as the judge for the integrated court in Victoria. And one of the questions that I really need to ask you is, what would be the difference between this court and the regular criminal court?
There are quite a few differences. Essentially, we try to have the court be less formal, and we try to create orders that are more specialized for the kinds of things we're trying to accomplish. And that requires some creativity. And the first judge who really was instrumental in starting the court, Judge Quantz, was very creative in finding ways to achieve the goals of plans and of sentences by the use of creative strategies with those sentences. For example, sentencing somebody by video in another jurisdiction so that they could get to the treatment center much more easily. Having sentences that had individuals who had to be sober for certain periods of time go into custody for a very brief period of time before they got shipped off to their treatment center. Those were the kinds of creative things that were done. One other thing that is different about the court is it is very much a court that attempts to have quick consequences. It tries to avoid those delays that are often associated with the traditional court. And the ACT team members are very assertive in making sure that when there is a problem with a particular offender, that offender is brought back to the court to explain what exactly the problem is. And they are held to account very quickly in the process, much more so than in a traditional court. Those are just some of the differences between the two courts.
And is this court unique?
It is unique, but at the same time, there are kinds of courts which are similar. Downtown Vancouver has its downtown community court. There are other specialized courts. There's a First Nations court in the Lower Mainland as well. There's drug treatment court in Vancouver as well. So those are specialized courts, which are the same as this court. But this court is unique in some of the ways that it has come together and the way that it tries to solve its own problems. It is a court that was very much grown out of this particular community and the particular problems of this community and the particular insight as to the way forward for this community.
Now, it sounds to me like this has to cost a lot of money. So what kind of budget are you working with?
One of the things that was essential was the recognition that there would not be any additional monies. And what would have to happen is that everybody would have to find within their own current operating budgets the ways to move forward. I can't speak to how other people did it, although I have seen the additional effort that they all have gone to, from Victoria City police officers to ACT team members to probation officers, all doing extra work to make success happen here. For our court, we worked within what we have, and we did so by carving out the extra Tuesday morning in which we could hear these cases, finding a way to do that, and then dedicating the personnel to it. So everybody has very much got behind the idea of putting in the extra effort without any additional funding.
Now, you sitting as the judge on Tuesdays, then what happens if you're having a case that's running on the Monday and it's a 3-day trial?
Well, usually I'm not scheduled for those. And so if there's a 3-day trial that wants to start on a Monday, it's not for me. And so the schedule is worked so that I will be available on Tuesdays. And by and large, I am available on Tuesdays. I won't miss many Tuesdays in the year to come.
So you must have developed some sort of a relationship with many of the people who come through that court.
Well, it's one of the benefits of this court, and it's a very positive thing about this court, that you do get an opportunity to see the people and to get a real feel for all the issues associated with their recovery and with them breaking the cycle of offending. And so, for example, I will see individuals who first come in and they're in the throes of addiction and they show all the signs of it. They're thin because they're not eating properly. They are not able to sit still in the chair because they're feeling the effects of withdrawal, perhaps. All those things you see. And then over time, if success is something which occurs, you can see them gain weight. Mm-hmm. They can start to look you in the eye. You can start to have conversations with them and ask them how they're doing. And so you do get to establish some relationship, although brief, with individuals, and sometimes get to witness some truly marvelous successes.
So what happens if someone's in the court, they do well for a period of time, and then you don't see them for a period of 6 months, let's say? Is there any way to bring them back to court if things aren't working out for them?
Yes. The usual mechanism is for the ACT team members to bring them back for a review. Most orders have provision for them to be brought back at the direction of an ACT team. Again, that's something that's more serious than what happens in traditional court and more onerous than what happens in traditional court. And then they come back for a review. And in open court, the ACT team member tells us what the problem is. The Crown will make a submission as to what is to happen as a result of that problem. The defense will make their submission, and then a decision will be made. Sometimes it's simply just looking them in the eye and telling them that this is not good enough. And the consequences are serious in terms of them losing their home, losing their support if they don't get back on track. And so those are the kinds of things that happen on a review.
So how would the role of Crown Counsel and Defense Counsel change from your observation?
It's challenging for both sides. For Crown Counsel, they certainly have to look at things from a different perspective insofar as they have to look at the long-term issue of the offending of this individual and not to just quickly decide that they should be breached for every time they do something wrong. So the Crown have to be very careful and prudent in what they do in order to assist individuals as much as possible. For the defense, the challenges are as large, but they are different. For the defense, they have to acknowledge that their clients may not be doing well. They have to acknowledge the problems that their clients face, and they too have to see the long-term benefits. They are much less involved in getting somebody off than in making things better for that individual in a way that that individual may not be too keen about being engaged in at the time. So both sides have to put aside their role to some extent and look at the whole problem and issue of particular offenders differently.
Okay. Now, I understand that prior to becoming a judge, you were defense counsel?
I was.
Okay, and how long were you practicing law for?
25 years.
Oh, okay. And how do you see your role as defense counsel working into your position as judge with integrated court?
Well, I like to think, perhaps I'm flattering myself, but I like to think that I have some insight into people, some insight into seeing the kinds of difficulties, problems they have, seeing how they've gotten out of those problems, how those problems have gotten worse. So I like to think that I have some sense of that and that I can see that in the people who come before me. So if I'm right, then perhaps I do bring some insight into the court.
And where do you see this project going in the future?
Well, I think that's something that we have to evaluate. And right now the court and all the stakeholders are involved in a review process that we hope will result in a report in the not too distant future that will summarize for the community, for whom we're all working, the work that has been done, what has been accomplished, and what we can do better in order to make this more effective for the community and for safety for the community.
And have you received any feedback yet? What kinds of response have you gotten from the community, the stakeholders, let's say?
Well, we're just starting to get that feedback. And generally the feedback is positive. Generally, we're starting to see some indications that the use of resources for some individuals is much less than it had been in the past, and so that those costs are saved to the community. We're starting to see certainly some anecdotal evidence that suggests that the business people downtown are seeing things improving to some extent. So we're starting to see some of the benefits of this court and to see the positives that can be accomplished by really engaging with some of the more difficult problems.
And what about some of the anecdotal stories of successes that you may have seen coming through the court?
There are a number of successes that you see, and I can tell you that they are very moving when you see them. And they are moving because you see individuals who had never gotten involved with the idea of treatment, indeed were against treatment, and yet through the engagement and the skill of the ACT team members, they have been brought around to be individuals who see that perhaps things can be different, and they see that things can be better, and they start to work towards those things. I've seen individuals who have said, I will never go to treatment, who go to treatment. I have seen individuals who have gone to treatment and have come out of it and have been so thankful to those around them, particularly the ACT team members, for really helping them salvage their lives. And that has been something that is really stirring to see.
And is there a plan to expand the court in any way?
Well, I think we have to consider that possibility and consider ways that we can do more and still be very effective. I think we're still in the stage of taking small steps, so we shouldn't try and run too fast. But at the same time, we should take stock of our successes and see where we can do better and see if we cannot do more.
And could you give us an example of how you could see it expanding?
This hasn't been thought through at all, but certainly one aspect of it is to see if there's any possibility for greater community work service and to get individuals more engaged in their community. For it is one thing to break the cycle of addiction, but that doesn't integrate you into the community. You have to be involved in the things that we're all involved in, the work, the hobbies, the things that help make you part of a community and make you feel part of a community. So that community work service may well be something that we can think about as a possible area of expansion, that might be something that could really give back to the community in a very tangible way.
Okay. And you're going to be finished there in March?
Yes, March of next year, my time will be up.
Okay. And so are you going to train a new person to take over in terms of the judiciary?
Well, it won't be a question of training anybody because we're fortunate in Victoria to have a highly skilled judiciary. But the next judge who comes into it will, of course, be informed as to everything that we've done, and will bring his or her insights into the things that we can do a little bit better into the future. So that new vision may be something that will help the court expand.
Well, thank you very much, Judge Brooks. You've been watching Island Justice with Roger Batchelor, and today we had the Honorable Judge Brooks, who is the judge for the Integrated Court in Victoria.
The proceeding was an independently produced community access program. The viewpoints expressed are those of the community access producer and do not reflect those of Shaw Cable Systems. The program is presented in response to CRTC policy guidelines regulating community programming.